And I'm a business development manager for Nate, based in Joburg. With me is my guest, Tim Mertens, chairman of Sovereign Trust SA Limited. Tim is a well-known radio and TV personality and is an expert in cross-border tax planning and changes in legislation. Welcome, Tim, and thank you for helping me unpack this very popular and prevalent topic once more.
Thank you, Arifa, and thanks to the team there, and many thanks for the invitation again. It's nice to be with you.
Thank you. Today, we are continuing our discussion in estate planning considerations in an offshore world. But what we're trying to do differently today is to try to make it practical for our audiences by going through some common scenarios most wealth planners are faced with. But before we start the session, just some usual housekeeping. This session is being recorded and the recording will be sent to you after the webinar. 1 CPD point will automatically be awarded if you attend this full session. If you listen to the recording at a later stage, you'll still be able to earn the CPD point by answering the assessment afterwards. As usual, we love hearing from our audience, so please post your questions you may have in the Q&A box at the bottom of your screen. And a very, very important disclaimer, the information and scenarios discussed in this webinar are generic in nature and should not be construed as tax or legal advice. Clients should always take advice based on their personal circumstances prior to making any changes to their tax or legal arrangements. Now that we've gotten that out of the way, the format we would like to follow today is a quick recap of our last session. Then we'll go into 2 case studies, and after each case study, we'll take questions from the audience based on each of these scenarios. Tim, let's get straight into this. At our last session, and I just want to remind our audience, we do have the recording available on innate.co.za should anyone want to re-listen to that. So at our last session, we touched on some very useful themes. And just for the benefit of our audience, I'd like us to recap some of the important points we discussed, please, Tim.
Yeah, sure. I think, really just to firstly position why we're really talking about this topic is that we know that over the last couple of years, there's been quite a dramatic relaxation in exchange controls. And we know that there's a lot of movement of people, families fragment, unfortunately, sometimes people move around with jobs and what have you, and there's a lot of cross-border activity going on. And when assets are being purchased in other countries from South Africa, it throws up a number of very important issues relating to onshore estate planning, because you're dealing with assets now that fall into other jurisdictions' laws, and they have to be taken into account, obviously, back here in South Africa, and very often in the jurisdiction where the assets are located. So there are a whole lot of topics that surround this, and one of them, of course, is the issue of a grant of probate. It's really UK-centric, and it really is akin, really, to providing or requesting letters of executorship that an executor would do here when there's an asset. It's not always necessary to get a grant of probate, as we were discussing last time, because certain assets don't really particularly need a grant of probate. For example, if there's an investment and that investment is registered outside of, for example, the UK, but there are assets in the UK under that investment, usually a grant of probate wouldn't be applicable in a case like that. So too, for example, with a bank account in the UK, somebody in South Africa sets up a bank account, it's under £10,000 perhaps, there wouldn't be a need for probate in those sorts of circumstances. So there are different scenarios relating to the type of asset when probate is, the probate process is required. And then we talked about, obviously, the great importance, and I can't stress this enough, of having a South African will, regardless of whether or not you have assets overseas or not. But it's very, very important to obviously have a local will, simply because you've built up your estate over time. You want to have freedom of testation to be able to have your assets devolve in the proper way and in a tax efficient manner as far as you can arrange that. And you can very often put planning into place to minimize estate duty, as we will see. And so it's a critical document. And also, on occasion, when there is an asset in another country, it's also appropriate then to have a will in that country to consider the asset, the situs asset in that case, of the asset in that particular jurisdiction. And you would really ring fence both jurisdictions. So a will for your South African assets, for example, and a will perhaps for your UK assets. Not always required, but certainly should be thought about when there are assets in other jurisdictions.
And of course, if you're passing away without a will, then you're dying intestate, and we obviously don't want a situation like that, because that's the worst thing possible, right?
Yeah, I mean, that really effectively is a disaster. And then, so we also then talked about very briefly the sorts of costs where there is a probate process in say, a jurisdiction like the UK. What sort of costs you might expect there. There are sort of two types of cost. What we call a variable cost, and that is really akin to our executors' fees, perhaps here in this country. They range broadly between 1% and 5% of the value of the estate. And then so-called fixed costs, which are very low and relate really to the application for probate, really again akin to the master's fee here. So those are obviously very important to consider as well. And then I think we also discussed very briefly the fact that one shouldn't overlook capital gains tax implications in an estate, because it's an unfortunate result that when somebody passes on, there's not only potentially estate duty, but there's also potentially capital gains as well. It's a double whammy, if you like, very unfair. But that's what we have to work with. And the deceased person is deemed to have actually disposed of assets when they die, and that's why the capital gains tax implication comes in. And then we also, just lastly to recap, we touched on UK inheritance tax thresholds and the US tax thresholds. Increasingly, we are seeing, for example, that people are investing in the US, property, setting up companies, etc. And so the US is obviously a jurisdiction to keep your one's eye on, because the threshold is very, very low. It's only $60,000, and then above that you're paying estate tax at 40%. So very, very penal in the US if there are assets in the US, significant assets. And then in the UK, if you recall, inheritance tax, the equivalent of our estate duty, kicks in after £325,000, again at a rate of 40%. So these are taxes that one has to really keep an eye on and really consider very carefully if they're going to be assets in other jurisdictions.
Excellent. Thank you, Tim, for that summary. And of course, I'd like to add one of the key things that came out from that session as well is that it's vital to seek proper financial advice, as we're faced with so many different factors that could influence these considerations, and not seeking that financial advice is obviously detrimental to any client. Tim, what I'd like to do now is look at our first case study. And audience, please remember to add your questions related to this case study, particularly in the Q&A box at the bottom of the screen. So Tim, we have a client. Let's call him Homer. Homer is married to Marge in Community of Property. They have 3 beautiful children, Bart, Lisa, and Maggie. Homer and Marge are both South African citizens and residents. They own their home in Springfield and have a holiday home at the coast. They each have local investments as well as a joint offshore investment in a pure unit trust at Innate, which is domiciled in Jersey. It's worth about $200,000, or roughly around 3 million Rand. They have a local joint will and are thinking about emigrating in about 2 to 3 years, because Bart would have completed high school by then. And they think the opportunities in the UK may be more appropriate for his many talents. Their financial advisor, Mr. Burns, who used to be a businessman, is asking you to help him with a few questions Lisa has posed to him. So, Tim, will Homer's estate be subject to estate duty in South Africa when he dies, even though he has offshore assets?
Yes, well, under Section 3 of our Estate Duty Act, it doesn't matter where the asset is located. So it's rather like taxation. taxation is brought into account wherever income or capital is earned throughout the world, and the same as with estate duty. So it doesn't matter if there are assets in other jurisdictions around the world; they all form part of the calculation potentially for estate duty. There may not be a estate duty given some of the initiatives that one can take to avoid it. But certainly it would come into the estate, and it would have to be valued and then considered as to whether or not there is a dutiable estate and what that dutiable estate is. But yes, so it doesn't matter where the asset is. If the Simpsons are, or Homer dies and he is a South African resident, then that is going to be considered for estate duty purposes. Whether or not estate duty applies or not is another matter. But because he is ordinarily resident in South Africa, he lives here, his home is here, his family is here, he would be deemed to be ordinarily resident, and therefore his worldwide estate essentially accrues to South Africa. And I think it just again highlights the fact that, you know, even if you have assets overseas, you can't, and they're in your name, you can't very easily exclude them from your South African estate unless planning is put into place.
Of course. So what are some of the ways Homer, together with his financial planner, can use to reduce this estate duty impact?
Well, there are a number of ways, and I think maybe it might just be a good idea just to quickly look at how estate duty is calculated. Firstly, if you like, at the top, you have property and what we call deemed property. So property would be, you know, house, shares, assets, portfolios, all the assets in Homer's estate or in Marge's estate, because it is a joint estate. So it would be all those assets, which would be property. And then if Homer did have a life policy, for example, that wouldn't be ever paid to him. That would usually be paid to a beneficiary. But that would be what we refer to as deemed property. So it would be property and deemed property, which would come in and there would be a value, what we call a gross value. And then deducted from that would be deductions. So under Section 4, you've got, for example, of the Estate Duty Act, you've got funeral and deathbed expenses, medical expenses, administration expenses, those sorts of things. And also, other deductions. And one very, very important deduction is under Section 4Q. And that's one that I think we all know about, where essentially if it's an interspousal concession, essentially if Homer leaves everything to Marge, then Section 4Q essentially says that there won't be any estate duty and there will be a deduction essentially to get to a net value. And that's the next big figure we get to. So we get to a net value. And minus from that net value is then what we refer to as the Section 4 capital A abatement, which probably we all know in the audience is currently at 3.5 million rand. That would come off, and then you would get to what we refer to as the dutiable estate, the estate on which 20% is going to be levied as estate duty if the estate is under 30 million, and if it's over 30 million, then 25%. So that's how estate duty is generally considered. Some of the ways that you can reduce estate duty in this particular case would be, well, one consideration is that the fact that there is an in-community of property estate, it would mean that after administration, costs, debts, and other liabilities in the estate, the joint estate now, remember, not just Homer's, because it is a joint estate. So the joint estate would be valued, estate liabilities, etc., would be paid. And then what is left, there would be a half share. And estate duty would only apply, obviously, on Homer's half share. So it wouldn't be on the full 12.5 million estate in this case.
Yes.
Then I've mentioned the Section 4Q exemption, which is very important. It's a good planning tool to avoid estate duty by, essentially involving a surviving spouse as part of, as the heir, to reduce estate duty. The other issue, of course, is utilizing the abatement in a clever way. Normally what planners try and do, that Section 4A abatement of 3.5 million rand, what they do is they consider perhaps in the will leaving that to a trust for the children. So it's out of, all estates, it's in trust, and then the balance can be left to the surviving spouse, meaning very, very estate dutiable, very, very efficient from an estate duty point of view. And then obviously over time, I think it's important to consider utilizing other tools that are given to us, and one being obviously the 100,000 Rand donation per year, which in a higher net worth family like this should be utilized, because it's a good way of just essentially trying to reduce the estate in some way. And remember, if that's donated to a trust or outside of the estate, then of course that can grow in of itself. So that's another issue to consider. And then, given that there may be immigration in a couple of years' time, it might also be valuable to consider some sort of offshore entity. If it's going to be the UK that the Simpsons go to, a trust is not going to work because the UK look through trusts. But you might then consider something like a QNAPS, a qualified non-UK pension scheme, to start to build something like that, simply to avoid, firstly to provide for retirement provision down the line, but the effect also is that you might avoid inheritance tax in the UK. Remember, if you leave South Africa and our estate duty rates are quite high if you consider when they kick in. If you go to another country, the estate duty rate or inheritance tax rate may be much, much higher. So if you can start to plan before you emigrate, that's also, quite a good way of looking at it. And then just very lastly, on this point, obviously retirement annuities, pension and provident funds are excluded as property. And therefore, if they are augmented over time, if contributions are made to those sorts of plans, then again, that's another way of excluding them from the estate. So there are ways of looking at it and reducing the liability potentially down the line.
Great. Thank you so much for all of those suggestions, Tim. Is there joint South African will sufficient to wind up the estate in South Africa should one of them pass away, or do they also need a foreign will, seeing as they have foreign assets? And just adding to that, will they need a new will when they emigrate?
Yeah, and the will, a joint will, there is a question very often as to whether or not you have a one will or two if you've got foreign assets. But I think very often what can happen is that if there isn't a probate scenario with the assets in this case in the UK, so if it was an innate investment or in an investment which is not registered in the UK, outside of the UK, probate wouldn't have to be applied for, and therefore you wouldn't necessarily need a will in the UK. So in this particular example, a joint will in South Africa probably would suffice. However, if the Simpsons were to now start to leave South Africa, start to plan to leave, for example, they may utilize their allowance, their discretionary allowance, purchase a property, which then would be a citus asset in the UK, then it would be very important, I think, ahead of even immigration to make sure that they have a will in place covering that asset, because it would be a citus asset. So in that case, yes, a will would be important. And if they didn't buy a property ahead of them going to the UK and they were just going to rent, for example, they would, as a matter of course, be bringing assets into the UK in their own name or anywhere else for that matter. And again, it would be appropriate to have a UK will. So yes, in both circumstances, I think, wills would be very, very important considerations, especially when that move takes place out of South Africa.
Excellent. And I know you touched on this and you said earlier on, Tim, that only half of the asset, the joint assets are subject to estate duty when one of them passes away, but they are married in COP, okay? Would this answer be different if they were married under a different marital regime where the entire estate is subject to estate duty and executor's fees, or half the estate is subject to estate duty and executor's fees?
Yeah, so, I mean, the thing about an in-community of property estate is that it has some shortcomings in community of property estates. They are beneficial in some ways, as you may know. If you're about to get married and you don't have an antenuptial contract, then you're automatically deemed to be in community of property. And essentially what that means is that you own one half share, you own one half of an undivided share of a joint estate. And that simply means that when one of you dies, the entire estate is looked at, is wound up. So it's not just one half of the estate that is wound up, it's the entire estate because it's a joint estate. And that obviously has its shortcomings from the point of view, especially of, if you think about executors' fees, for example, because executors' fees will be charged on the full estate. So if you take executors' fees in this particular example of 3.5%, remembering that you've got to add that as well, you're looking in the region of R500,000 on a 12.5 million rand estate. Whereas if it was an in-community of property estate and you just had completely separate estates and one of you died, then it would really only be executors' fees on, and potentially estate duty, I must say, but there may not be estate duty. There's always going to be executors' fees, but the executors' fees would be a lot less. So I think it's important to consider the marital regime when you are, putting together an estate plan, because executors' fees can come and bite you, and it's just, that's money gone. It's just it's a big cost to the extent to in-community property estate.
Thank you. Tim, do the new rules of financial immigration have an impact on their investments, both locally and offshore?
Yeah, well, there's been a lot in the media about this, and obviously there have been TLAB and other legislation that has been circulated, as you know, for comment, and it's a bit of a hot potato because everybody was talking about financial immigration. What is it? People were getting confused about it, and I think what has happened now is that it's been clarified from the point of view that essentially financial immigration doesn't really exist anymore, but it has been replaced with a system, the so-called 3-year rule, which I think many people know about, and that essentially that, pension provident retirement annuity funds that the Simpsons, in this case, may have onshore, will essentially be blocked for a period of 3 years if they emigrate. From the 1st of March this year, it came in. And although, there are some in the marketplace that are saying, well, it clarifies the situation and it makes things fairer in that residents who haven't perhaps attained the age of retirement can't access their pot, but people who now seemingly have emigrated overseas now can. That's unfair. It does highlight some problems, this issue of saying, well, you have to prove residence in another place for a consecutive period of 3 years, because as we know, it flies in the face really of, the ordinarily resident definition or the physical presence test around what a non-resident is. And, there are other practical issues around it as well. And that is that if the Simpsons in this case actually leave South Africa and, Homer wants to, draw down on his pension as part of his settling in process in another country, he can't, because he's got to wait for 3 years. So it can be very, very limiting in that sense. And I think there are some inherent problems there with that. But look, that's what we've got to deal with at the moment, and it's got to be very obviously carefully looked at when you're immigrating.
Yes, and I know we went through this while you were telling us about the estate duty calculation broadly, but how is CGT dealt with on debt?
Yeah, well, then again, as we mentioned the last time, so CGT, again, just mustn't be, it just mustn't be ignored, because when an estate is being planned, when a liquidity or cash analysis is being planned in an estate, because essentially you've got the values, the base cost, obviously, and the market value values of the asset, which can become quite complicated and complex. So you've got that. And obviously the process and the principle here is that, as I mentioned earlier, is that when somebody passes on, they are deemed to have disposed the asset. And it means that the executor or executrix winding up the estate has to take that into account when they file the last tax return of the deceased person with SARS. They have to actually consider the potential capital gains tax implications and pay the tax. So it's, as I mentioned earlier, it's a bit of a double whammy, because not only do you potentially have estate duty, but you're going to have capital gains tax as well. So it's a very, very unpopular tax, but again, it's just one of those things that has to be considered very carefully.
And Tim, so if there is a shortfall in the estate in terms of liquidity, will the offshore assets need to be disinvested and brought back to South Africa?
Yeah, well, I think the thing is that, when somebody dies, so if Homer dies, what the executor is going to have to do is to consider what liquid assets there actually are to pay estate debts. We don't know what Homer's will says, but he may not have left everything to Marge, in which case there may be estate duty implications. He may have just left the abatement to Marge and then left assets elsewhere to perhaps the children. We don't know the situation. But in the event that there is estate duty and there are other debts, perhaps there are liabilities in the estate, then they have to be paid, obviously, and that's where the liquidity comes in. If there isn't enough liquidity, then obviously the executor has to go to the heirs and or sell assets. In this particular case, I think the estate is liquid because you've got that offshore investment. And I think that's, that would be probably enough if, depending on what the estate duty liability is. But obviously, as all the listeners who are financial planners will understand and appreciate and know a lot more about it than I do, is that obviously one of the best ways to create liquidity in a estate obviously is by taking out a life policy, because that's quick, easy, relatively cheap, and it creates liquidity in the estate. And I think the trick here is to do it sooner rather than later, and to make sure that there is liquidity at fairly low cost in the estate. And it's a great way of avoiding a whole lot of problems when assets have to be sold. You get infighting between heirs because they don't want the assets to be sold. It may be a valuable property and some heirs want it, others don't. And it can take sometimes years to wind up an estate on a simple thing, over liquidity, when it could be solved very easily with, as I say, with something like life cover.
Exactly. And I think what you've highlighted most here is that a will is critical and that there are so many factors that come into play. So thank you very much for all of that information, Tim. What I'd like to do now is go to our audience to take some questions on this case study. Okay, so we have a question from Kagisho. Thank you for your question. Please recap how the 3.5 million rand abatement is donated, transferred to a trust.
So under Section 4A of the Estate Duty Act, you have 3.5 million rand, which essentially is free of any duty. So one consideration is to simply say in your will, to have a clause in your will that you donate, or you bequeath, not donate, sorry, but you bequeath 3.5 million to a trust to be formed. Maybe in this case, a testamentary trust, a trust which is only set up in the event of the deceased's passing. And that would be 3.5 million rand completely free of estate duty, any estate duty, into trust. So one good way of creating, an asset, of divesting an asset to trust, which in the future won't be subject to estate duty. And then, as I mentioned earlier, if you utilize that concession of Section 4Q, then you could, leave the balance of your estate perhaps to the surviving spouse, and then there wouldn't be an estate duty liability. So the abatement can be used in that way, or it can just be brought in for the calculation of, if there's a large estate duty liability, you can just bring it in and you can reduce the estate in that way, the estate duty liability.
Okay, speaking of 4Q, here's a question from Pam Evans. How are permanent life partners treated with regards to 4Q, Section 4Q?
Yeah, that's a very good question. There's, I think at the moment, my understanding is that that provision doesn't apply. I don't think that if you leave your estate to a life partner, that life partner benefits, or the estate benefits from Section 4Q. But obviously that is an area that probably needs to be amended and looked at, because there are all sorts of different types of situations in South Africa. There's African customary law. There's all sorts of different types of, circumstance. And on that basis, that is something that should be considered in the future.
Excellent. Thank you. Here's another question from Steph. Thanks, Steph, for your question. What is the view on ETFs in terms of citus, inheritance tax? Could these investment solutions be used as alternatives to mitigate citus tax in offshore portfolios?
Yeah, so ETFs are rather like unit trusts and wrappers and other types of financial instruments. If they are registered outside the jurisdiction in which they are actually applied, so if there's an ETF in the UK but it's actually registered there's a registration outside of the UK, then that wouldn't form part of a citus. It wouldn't be a citus asset, certainly not in the UK. So that would fall outside the scope of probate.
Okay, and here's a question from Tegan. On their joint offshore investment account, if Homer had to pass away and he was the one that applied for the 1 million rand tax clearance, or greater than 1 million rand tax clearance, would the surviving spouse have to apply for the tax clearance in their own right to keep the funds offshore? That's a great question, sir.
Yeah, that's a very good question. Look, if only one of the, technically they both own the asset. So really it should be a joint application. They both need to give consent essentially to make that investment. So if Homer is the only one who's done it, then I think my view is that the executor, if the balance is going, well, Marge owns half. I think then it should be the case that it should be regularized with the other half, for sure. It should have been done. They both should have done it up front, but it should be regularized. Marge should regularize it.
Okay. Here's another one from Pam. Can an executor be paid whilst winding up the estate before the master approves the L&D account? Especially if it takes years to do so, there could be complications in winding up that estate.
No, generally speaking, the executor is really paid right at the end. So when the liquidation and distribution account has been drafted, it's live for inspection, land for inspection with the Master of the High Court and with the local court. Once there are no objections, then the master essentially gives clearance to distribute the assets. And it really is right at the end that the executor's fees are then deducted. It shouldn't be done along the way. I suppose, if an estate, if there's a contested estate, if there's an insolvent estate, perhaps, if there are major problems and issues, if there are conflicts of law with other assets overseas and it's taking a long time, then I think what can happen is the executor or executrix can approach the Master of the High Court and discuss that with the master, but really the executor should be waiting until the estate is wound up and the master's given final clearance before the executor's fees are paid.
Okay. Here's a CGT question. There is no rollover to a spouse unless the spouse is a US citizen. Is that the same for the UK?
No. So in the UK, the interspousal concession is applicable. So if you have an asset in the UK and it is left to a surviving spouse, then inheritance tax is not going to apply. But in the US, what happens there is that you are regarded as a non-resident alien if you have an asset in the US. And on that basis, even if you leave that to your surviving spouse, who is not a US person and not a US resident, then that is not, there's no spousal concession applicable. If that person is a US resident and a spouse, then there wouldn't be estate tax in the US. But if not, then unfortunately, that concession is not going to be available.
Okay, here's another question from Daniel. Please clarify when it would be more beneficial for an offshore investment to be structured in a wrapper rather than a direct unit trust for probate and estate duty purposes.
Well, both of them, both of them are going to fall into the estate in South Africa. I think the benefits perhaps with wrappers is that you're obviously paying portfolio tax along the way. On that basis, there are tax benefits. Unit trusts, I'm not really familiar with unit trusts, how they are taxed in particular, but from an estate duty point of view, it's the same. They would both be valued for estate duty purposes back in South Africa.
Okay. Here's another question. Will there be transfer cost payable when a property is bequeathed to a testamentary trust? That question's from Barry. Thank you, Barry.
No, so estate transfers usually are free of transfer duty. And so that is one of the benefits essentially of immovable property when that is moving around within an estate. So yeah, there are no transfer charges in that regard.
Okay, Tim, we have a question here, but I don't think it's related to this. I'm very happy to ask it, and you can share your view if you want to or not, entirely up to you. How is cryptocurrency viewed?
Well, that's a great question because it is all the rage, isn't it?
Yes.
And I think the problem that we have actually at the moment is really the enforceability and even the knowledge around the fact that it even exists. Yes, assets can go off a balance sheet and they go somewhere. So if you're buying cryptocurrency, Bitcoin or Ethereum or any of the others, assets are leaving your estate, and presumably then in your tax return, you've then got to report where they're going. But it's a very difficult one because essentially, it's not an asset, well, it should be an asset on your balance sheet. And as such, it would be valid for estate duty purposes. But I think we all know that people feel that they can get away with holding a cryptocurrency and then just passing it on to somebody else. It's rather like the old bearer share. If you held a share as bearer and you then just, you took a bit of heat, you just pass that share over to the next person and now that person is the owner. It's rather like that. And I think our laws are really behind when it comes to, dealing with assets like cryptocurrencies. And I know that there are moves afoot to try and, rectify that. But yes, technically, that cryptocurrency asset would be an asset on a South African balance sheet. And if that person died, then it would be valued as part of the estate duty calculation.
Okay, last question in the interest of time. It's from Derek. So a very quick answer to this, Tim. What happens if undisclosed assets of a deceased are discovered after their estate is wound up from an estate duty payable and a transfer of the assets to the beneficiaries is concerned?
Yeah, another great question. Well, the executor or executrix is tasked up front with finding, and bringing in, remember that property under Section 3, property and deemed property. And yes, sometimes I think there are situations where the executor just simply does not know about an asset. And if it comes to light later on, then it's a matter of that executor then having to go back to the Master of the High Court and reflecting that as a new asset. And yes, potentially the L&D account, the liquidation distribution account, would have to be recalculated. It would have to lie for inspection again. And that asset would have to be brought in the normal course. So potentially estate duty would have to be payable on that. And obviously SARS would have to be advised about that. But another great question, because that does happen from time to time.
Yes. Thank you, Tim. I think let's move on to our second case study now. Okay, so our second case study is related to Donald. Donald is a UK citizen and lives in South Africa. He's 65 years old and he's not married, although I must tell you, he has been seeing Daisy socially for some time. He has no beneficiaries or next of kin and is now retired. Donald only has a UK will. His primary residence is in lovely Duckburg, right here in South Africa, and he has a holiday home in the UK. He has an offshore endowment worth about £400,000 and some personal Walt Disney shares valued at about 500,000 US dollars. He also has a living annuity with a market value of around 10 million rand. So Tim, this is a little bit different to the second scenario where the first scenario where the clients were actually South African residents. Where is Donald tax resident? If he passes away, which country has the right to make him pay death taxes?
Yeah, so in this scenario, he is definitely South African tax resident. He has his primary residence here. He wants to reside here. I think he would be probably deemed to be ordinarily resident here. But so South Africa, I think, would definitely have jurisdiction over his estate. The fact that he's a UK citizen throws up some interesting issues, and again, this highlights the movement of people cross-border and that have different nationalities. The UK is slightly different from the point of view that they have this concept of domicile. And domicile is a very, very important and strong feature of being part of the UK and being a UK citizen. It's different, of course, from residency. So Donald can be a resident of South Africa. He may not be a resident of the UK, but he will be probably domiciled in the UK, and that means a domicile of origin. You normally get that from your father. And if you don't have a father, or your parents were not married, then it's usually the mother. But normally it's the father's domicile that you take. And you can then have a domicile of origin. In other words, you can set up somewhere else and then say, right, I'm cutting all ties with the UK and I'm no longer a UK dom, as we would say. But that's very, very difficult to overcome. And in all likelihood, Donald is UK domiciled. And that means that although he's not resident, the potential for IHT, for inheritance tax, exists in the UK, even though South Africa definitely regards him as a resident for tax purposes here. The UK, simply because he is domiciled in the UK, would also have a claim over his estate for IHT purposes. So it's a very, very invidious position. And even if he was to argue, look, I'm here, I've got my property here, I live in South Africa, I don't intend to come back to the UK. The one point in the slide that you'll notice is that if he has a holiday home in the UK, HMRC could argue surreptitiously, look, you're domiciled, and probably, you would return because you've got a property here and, you've got that flexibility. And so to lose domicile in this situation is very, very difficult. In other words, to cut the UK out is very, very difficult. So it's very likely that both jurisdictions would claim over his estate, which is, again, as I say, a very invidious position to be in.
But then that double taxation agreement would come into place, hopefully.
Yes, so there is a double taxation convention, estate convention between the UK and South Africa. And that simply means that on the citus asset that obviously exists in the UK, which is obviously Donald's house there, that is a citus asset, that would be valued for probate purposes there. And yeah, essentially, that would have to come into the net for probate purposes, and tax would more than likely be paid in the UK. Let's just look at that. So 350, yes. So because of 350,000, his estate, he has a nil rate band, what we call a nil rate band, of £325,000. So essentially, he would only pay 40% on £25,000. But that credit would then be credited back here in South Africa in his estate here. So that's how the double taxation convention works. If, for example, he had an asset in another country where there wasn't that convention, then obviously the danger there is that double taxation can apply, and that is obviously a disaster. So again, very, very important to make sure that proper planning is put into place when there are cross-border assets.
Which leads me directly to, he has two sites as assets, his UK property and his share portfolio of the Walt Disney shares. What special planning should his advisor be considering when it comes to these assets?
Yeah, well, I think that, let's just deal firstly with the US property. Those are cited as assets for UK estate purposes for sure. And I think probably one of the most important things to consider here would actually be to sell those shares and to invest them in a platform or in an investment or something which is registered outside of the US. You can still ultimately invest into the US, but have the registration of that investment outside of the US to avoid US estate tax. Or, of course, you could transfer perhaps in specie those shares to a platform or to an investment of some sort, again, with a registration outside the US. Because the US, it's a complicated jurisdiction. We've mentioned already before that, the threshold, the NRA status, your non-resident alien status, terrible way of sort of considering you're an alien, but yes, you're a non-resident alien for tax purposes there. And the threshold, again, as I mentioned earlier, dangerously low at $60,000 US. And above that, 40% tax. So it's a huge whack. And it's just with simple planning, you can avoid that tax by, essentially having it registered offshore. So that's the one thing about the US. And then from the UK perspective, he might want to consider something like this qualified non-UK pension scheme, QNUPs. Yes. It's only really used in limited circumstances. And again, it must be for retirement purposes. It mustn't be used for tax planning arrangements. But that is an option. He could consider potentially transferring his UK property to a QNUPs. Of course, he would have stamp duty and land tax, the equivalent of our transfer duty, that would apply. And so it may not be worth his while to do that, but at least that would be out of his UK estate for IHT purposes. So that would be one consideration to make. And then obviously he must have a will in both South Africa and in the UK. If he has assets in the UK.
Okay, I just want to remind the audience to please continue to put the questions in the Q&A box. Here's a question. He has a UK will and no South African will, Tim. How does this impact the winding up of his estate here in South Africa?
Yeah, well, then you see essentially what is happening in a situation like that is that he's dying both testate and intestate, which is a complicated scenario. Because in the UK, he's now dying testate, and probate, the whole probate process is going to apply and his will is going to be followed. And because he's UK domiciled, again, as I mentioned earlier, the potential for calling in his South African assets into his UK estate is just that much greater. Yes. And it's a real complication. From a South African point of view, it's an absolute disaster because basically his worldwide estate now, all his assets in the UK, his assets in the US are now essentially falling under the Intestate Succession Act here, simply meaning that now an executor will have to be appointed, somebody who, some arbitrary person, an attorney or somebody to wind the estate up, not somebody that perhaps Donald would have chosen himself. And then most importantly, there's then no certainty as to, where those assets are then going to be devolved to. And again, a major problem because if you have no will, then maybe a court direction would have to be sought saying, well, perhaps you follow the UK will, but the UK will is the UK will. it's a complicated situation, and it throws up all sorts of different types of hassle and problems. So again, very, very important to have a valid will in both jurisdictions.
Okay. So what happens to his assets, Tim, when there are no beneficiaries, like in Donald's case now?
Well, usually then the terms of the Intestate Succession Act apply, and this would be the same in a jurisdiction like the UK, for example. But here, what would happen is that the beneficiaries would essentially be dependents, and so there's a prescribed formula that applies as to who the dependents are. So it could be children, it could be siblings. If he doesn't have children or siblings, then usually it would go up, as we say, and it would then be probably parents. But if there is literally nobody, then disaster, it goes to the state. So it's forfeited to the state. And, again, that's just a situation that can be very, very easily avoided. And of course, it comes with all the uncertainty and the cost and the problems and issues around a situation like this, which, as I say, just can be avoided by simply having a will.
Okay, great. So what we're going to do now is we're going to go to audience questions on this case study. Thank you so much for all of that information, Tim. Here's question 1. Would Donald's SA living annuity be a deemed asset for IHT in the UK?
Probably not. No. I mean, if I think what would happen is that you would have a conflict of laws here. It would be valued, obviously, in South Africa, but from a UK perspective, I think we would probably have the taxing rights over that. But again, it may well be that, HMRC in the UK say, no, look, hang on, he doesn't have a South African will. And on that basis, the assets are UK for tax purposes. And they might make a very strong case to pull those in. But with a will, a South African will, then they would probably be South African for tax purposes, and be brought into, when I say tax purposes, be brought into the calculation.
Okay, so here's another question from Dave. If there's an execution-only portfolio, that is, he makes the calls on the trades as opposed to a discretionary portfolio in the offshore wrapper, is that also protected from foreign inheritance tax?
Yes, it would be, because it would be the wrapper that would be the important product, essentially, that and if that's not registered within the UK, then probate wouldn't apply in that situation. I mean, he has some form of control, but that doesn't necessarily mean that probate is then going to apply.
Okay, so I know we spoke a lot about this, but here's a question related to wills from Julian. Wouldn't the UK will be international? That is, he wouldn't die intestate here if he had the UK will?
Yes, well, I mean, because he's resident in South Africa, you see, and he has assets in South Africa, then South Africa is going to claim jurisdiction, should I say, over his South African estate. So there is this conflict of laws. Yes, there's a will in the UK, but South Africa is not going to recognize that will because that's in relation to perhaps UK assets. It depends, obviously, what the will says. But South Africa is going to definitely claim jurisdiction because they're going to say he's a resident here, he died in South Africa, he's got South African assets, and therefore the Intestate Succession Act is going to apply here. So there isn't an immediate default position that because he doesn't have a will here, it's now all under the UK will. He would die intestate here, but obviously he would die testate in the UK because of the will there.
Okay. Tim, here's a question, different take to it. If Donald wants to emigrate to South Africa, what can be done to mitigate the potential estate duty in the UK?
Yeah, that's a good question. If Donald really puts down ties here, he perhaps sells his property in the UK. he really demonstrates that this is now the country of his ordinarily residence. This is where his domicile of choice now is, and he's cutting his ties entirely with the UK. Then a period of time, would have to elapse. Don't ask me what period that is, because there's no defined number of years. But the case gets stronger and stronger and stronger. The longer he stays in South Africa. And, there have been even cases, for example, where people have bought burial plots in other jurisdictions. They've got golf club memberships. They've got, family roots that they've really put down, and other roots that they've put down in that other jurisdiction to demonstrate that they are no longer, in the UK. But it's still very, very difficult to lose your UK domicile. If you take, I'll give you an example. If you take my father, for example, he left the UK probably about 50 years ago. Now he's still regarded as domicile in the UK, but he's been in South Africa, for a very long time. No intention to go back to the UK, and so his will be, it's a South African will. If he had assets in the UK, he might have a UK will there, but it would be only in relation to those UK assets. And it's probably very unlikely that on the basis that he is still, deemed to be domiciled in the UK, that the UK would now come after his South African assets. But it's really a matter of intention and what you're able to demonstrate to the tax authority at the time, or during your lifetime, as to where you've put down roots. And of course, it's very difficult to argue that you're not domiciled in a place when you're dead. So it's got to be, during your lifetime, you've got to make that determination, and you've got to demonstrate. I might just add that in the past, it was popular to try and test your domicile in the UK by simply making a transfer above £325,000 to, for example, a non-resident trust. So if you made it £350,000 transfer out of the UK, if HMRC came along and said, right, well, hang on, you UK domiciled, you get the nil rate band, but you've got to pay the tax on the 25,000. Then you know that you're domiciled in the UK. If they say you're not domiciled at all, then you might still pay some tax, but at least you then have that knowledge. Now they don't do that anymore. They don't. You can't test them in that way, and you can't write to them and say, "Am I domiciled or not?" So it's a very, very difficult situation with the UK, and all the more reason why planning is important.
Excellent. Tim, last question from the audience, so a quick answer. Also related to this citizenship, if Donald had dual citizenship, that is both UK and RSA, would that impact on the IHT situation?
Well, again, Donald is probably UK domiciled. So if he's a citizen of both South Africa and the UK, then the UK still has, that control over domicility. So, that's the thing that you've got to overcome is the fact that you are still UK domicile, but you would maybe prove in that case that, you've never lived in the UK, you may have got the passport from your parents, and therefore on that basis, the domicile argument is very weak from the UK.
Okay. So Tim, we've come to the end of the session, and as usual, it's been great chatting to you. Thank you as always for sharing your expert knowledge and wisdom with us. For the audience, our next Innate in the Room series is next week, Tuesday, 25th May. Be sure to register for that with Steve Backhouse and Laurium Capital. The invites have gone out, but if you haven't received it, visit innate.co.za or our LinkedIn page. Next month's In the Room will be a little different. Max Dupriya will be chatting to Chief Economist Kevin Lings from Stanlip and Annabelle Bishop from Investec. keep an eye out on your inbox for that invitation. Also want to say a huge thank you to our wonderful audience. We didn't get to all of your questions, but watch out for our thank you mailer, which will address any questions we didn't get to. Please also feel free to reach out to your business development manager, who are always available to take any questions you may have. Their details have come up on the screen now. And before we go, I want to say a big shout out to Georgina Smith, who is today attempting her second swim from Robben Island to Big Bay. George, we're thinking of you, and we just want to say you've got this. Have a lovely day further. Thank you, Tim.
Great pleasure. Cheerio.
Sure.